The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Siniard Law has again received recognition as a Tier 1 personal injury firm by Best Lawyers in America. Tonight we are discussing premises liability. Bart Siniard is joined by another attorney in their firm, Barnes Heyward. Good evening to you both. This is going to be a good topic.
Good evening. Happy to be here.
Good to see you, Aaron.
Good to see
Talk
you
a
guys.
little bit about some of the craziness that can happen when people are hurt at somebody else's property, whether that's a business or a landlord or a friend's. But we'll see what people are asking tonight and see if we can come up with the answers.
Some of them almost sound like something out of a movie or that you made it up, but really this stuff happens.
Yeah, there's some crazy stuff that you know, in a personal injury firm, we have like different category of cases like car accidents, nursing home neglect, but we do have a whole category we just call miscellaneous. Some really crazy and tragic things can happen just in bizarre situations. You can't predict them, you can't categorize them, but we're always trying to look for is there a way to recover compensation for this person?
Right. And if you have questions on this topic or any other legal topic, all you have to do is email us at questions@siniardlaw.com or call us at 844-7000-LAW, and your question may be featured. Now to our legal tip of the week. What can you do if you get injured in a store? And this happens frequently.
Yeah, we handle a lot of these cases. Barnes, what do you tell somebody if they've been hurt in a store setting?
Yeah, I mean, the first thing that I tell people is that premises cases they're hard cases. Actually, there are a lot of lawyers, a lot of personal injury lawyers who don't like to fool with premises liability cases. And Bart knows there are a lot of defenses that, affirmative defenses that stores can raise that protect them from liability. And also, they're also the type of cases that they settle less often prior to having to file a lawsuit. If somebody's involved in a clear liability rear-end collision, there's no dispute about who the responsible party is. And so those types of cases, we're hoping, and most often we do get it settled without ever having to go to court. Premises cases, because of the defenses that are available, we're having to file a lot of lawsuits in those types of cases. So that's the first thing that I tell people, is just that they're tough. They have to be well documented. We have to look at in some cases, there are different standards of care or building codes or authoritative sources that we can look at to see whether or not the premises was in the shape it should have been. But they're so fact intensive.
They really are.
Yeah.
So this is one of those times like people ask you guys frequently, do I really need a lawyer?
Yeah, and
in this case, you probably do.
Let me go back to bare bones basics, because we throw around the phrase premises liability like everybody knows what that means. And premises liability is anytime you are hurt on somebody else's property. And the laws vary on what type of property you're on and why you're there. For example, if you're at the Walmart or any store that's open to the public, they have the highest duty to people coming onto their premises because you are there to give them your money. Those stores that are open to the public, they have a responsibility to warn of hazards and to inspect for hazards, and to fix those hazards that they know of or that they should know of. You don't have to prove that they knew of a hazard. You just have to prove that they should have known about it and didn't do anything about it. And hazards can be anything from, slippery substance on the ground. It can be stairs that are not within code. We've had a lot of those cases where one stair is, 10 inches and the next one's 14 inches. Well, that may be a case because that's not up to code. It can be I mean, it can be anything. We've seen a lot of things. Display racks that are not secured and fall off when you're getting an item out of the end of an aisle. But if it's a store that's open to the public for profit, they have the highest duty to their customers when they're hurt. The next level down is what's the law calls a licensee, which is just a unnecessarily complicated word to describe the fact that you're going over to somebody else's property, not for their benefit. So that could be just going over to a friend's house to cook out, or, it's usually going to a friend's house or somebody's house, or something of that variety. That person has less of a duty than a public store has. It just has a duty to warn of dangers they actually know of. Remember, a public store has a duty to warn of dangers that they know of or should know of. Like a private homeowner's they have to warn of dangers they actually know of. And then the next level down is the trespasser. The trespasser pretty much enters at their own risk. However, there is some law that essentially, I won't say the legal phrase because it's complicated, but you can't booby trap your property for trespassers. You can't dig out a pit and put a camouflage dressing on the top of it and have spikes under there. You can't booby trap a property just because you think somebody's trespassing and hunting on your land.
But that's your property.
It is. But you cannot set up traps that could injure or kill them. That's not allowed in Alabama and I think every state. But that's the only rights a trespasser has, is to not, be trapped and maimed.
I thought you were going to say attractive nuisance. That's the phrase I thought was going to come out of your mouth.
We'll bring that up next show.
All right.
Maybe this one. We'll see.
Let's get to our first question tonight. This one is from Brianna. I was at the Walmart doing my shopping and a box of tomato cans fell off the top shelf. Bart, you were kind of talking about this, onto my thumb. I am going to have surgery now. Walmart did an incident report, but the claims person now says they are not liable. I demanded to see the video of what happened, but they say they don't have cameras in that part of the store. Clearly, they are hiding something. Will you take my case?
Ooh, what do you think?
So I would love to talk about that. And the first thought that I had is whether, Brianna, you're right about, is there footage of what happened? I've actually dealt with this issue, not just with Walmart, but with a lot of stores, especially where you've got 100,000 square feet that needs to be covered by video. A lot of stores won't place cameras on aisles where it's low value items or items that aren't likely to be stolen. And so it's actually very possible that there wasn't. If we're talking about tomato juice, that's very possible that there wasn't a camera there. Now, I think that is problematic for a number of reasons, because it sounds like maybe you were reaching for something on one shelf and then this box was on a higher shelf and it fell, it landed on your thumb. It would be interesting to know whether or not that box was as it was when it was stocked by a Walmart employee, whether another shopper at the store came by, maybe they moved it so that it was at a point where it was about to fall off. I think, if I'm Walmart, that's probably the defense that I'm going to raise, is that another shopper in the store very well could have moved it, or that she could have moved it when she was moving things around on the shelf. And so video certainly would have been helpful there. I think right now it's not possible for us to say whether or not you have a case or whether you don't have one. It would be nice to talk to you, learn a little bit more about what happened. I hate to hear that you're going to have surgery on your thumb. That sounds terrible, but it's just going to come down to the facts, and the incident report would be nice to see as well.
Getting video is tricky because legally they don't have to give it to you. They don't even have to tell you whether it exists or not. And it's so frustrating because people are like, I'm hurt in a store. Can't you just show me the video? They are all trained at these major retailers to not give it to you and sometimes not even tell you whether it exists or not. They don't have any legal requirement to give video from within their store to a customer. In fact, almost all of them have policies and procedures where all of their staff are instructed to never share video footage. So the only way to go about it is you got to hit them with a preservation of evidence letter. And that basically something I type one a week where it says, hey, we think you're in possession of video footage. Please preserve this footage in the same or similar condition as it may be important evidence in my client's case. Once they get that letter, and send it via certified mail or hand delivery so you have proof it's delivered and save the proof. Once it's delivered and you can prove it's delivered, they then have a legal obligation to preserve the video. They still don't have to give it to you though, but at least you know it's locked in. The only way you may actually can get it is by filing a lawsuit against them. And I hate it when I get into these situations, especially where I know there's video and they won't show it to me. And I'm forced to file a lawsuit, and I don't know whether the video is good for my client or bad for my client. And I usually just tell my client, I was like, listen, we're going to file a lawsuit. We're going to get this video. But if it's bad for you,
be honest.
Yeah, we may end up dismissing this case. If the video shows that, you know, you did this yourself or weren't taking, you know, safety measures, you know, we may have to dismiss it. I will say this though, when they voluntarily give me the video before filing a lawsuit, it's usually bad for my client. Because they want me to go away, and I do if it's bad for I'm not going to take a, you know, frivolous case that I can't win. But so when the video is bad for me, they usually just give it over. But when it's good for me, that's when they're like, we're not sharing it. So
it's a pretty good indicator.
Yeah, I mean, it's not 100% true.
When it's bad, they're usually pretty excited to show us the footage.
Yeah, they're like, let's get on a Zoom call and I'll share my screen and show you how your client, you know, did X, Y, and Z and caused her own injury.
Yeah.
That happens a lot, and I watch it and I'm like, yeah. It's the cases where they're like, we cannot share the video. We cannot share the video. I've got one right now against a gas station where my client fractured her kneecap and they won't give me the video. And I know it's on video because I went in the store and there's a video camera right there. So I'm pretty sure it's good for my client. And we'll see.
This reminds me though, what you guys have said, that it's important to try and have a lawyer to get this information to preserve that, because it just gives them another excuse later if you waited too long. Oh, well, we erased them. We erased the video from that date.
Yeah.
Had that happen too.
You know, video overwrites. I mean, it's true. You know, some systems it goes away in 10 days. Sometimes it's 21 days. Usually surveillance video is 60 days, but I've seen 21 days and I've seen 10 days. Where it's like, it's not their fault if it goes away. It literally just overwrites and the data disappears. That's why it's so important to serve that letter on them demanding they preserve the video. Because if you deliver that to them and you save proof that you delivered it to them, and then it no longer exists, then they're in the land of what we call spoliation. You want to talk about that? We got a minute or two.
Yeah, I mean, if they have evidence, definitely, if we've sent them a letter asking them to preserve it, but not necessarily do we have to send a letter. But if they have evidence that they know would be important for litigation and that they think that, hey, there could be a lawsuit filed over this issue, and then they go and intentionally destroy that, you know, the court can impose sanctions against them. The other thing is that the jury instruction that comes along with it, basically the judge. So from our point of view, we get to ask the judge to tell the jury before they go and deliberate that, hey, this party over here, they destroyed this evidence and you are to assume that it would have hurt their case, and that is extremely powerful.
When the jury walks back to deliberate and the judge has told them you are to assume they intentionally destroyed evidence and it was bad for their case, they're going to pay a lot to settle the case.
Definitely.
Or we let the jury decide.
All right. Well, thank you both very much. Stay with us. We will have more of your questions, and we'll tell you how you can sign up for Siniard Law's newsletter coming up.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code or be sure to sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. This question is from Kendra. She says, last week while I was walking into my office building at work, I tripped over a curb that was not marked. HR told me that I am not the first person to trip there. I ended up hurting both wrists and my shoulder. I am now being told that my workers' compensation claim is being denied. What should I do?
Why would they deny that?
I'm wondering, okay, so there are two assumptions to make here. One, that the place where she works, so I assume it's a curb, it probably happened in the parking lot, near the entrance of the business. If the parking lot is owned and controlled by the business that she works for, and that's where all the employees who work there park, then I don't know why they denied it. I think case law would support that she is within what the law would say the line and scope of her employment. It just means that she's basically already started her job the second she gets out of her car, okay? Yeah. But if she works for a company that, let's say they have a suite in a large office complex, and that parking lot isn't necessarily owned or controlled or maintained by the business that she works for, then it may be arguable that at that point in time she hadn't started her employment, which is just a tricky legal issue.
That could be it.
But
or that it's not that her employer's responsibility, but the owner of the building, right?
Yeah, and in that case, that's what I would tell her. And at Kendra, I would say that, first of all, you need to go talk to a lawyer. And I think very likely a lawyer could get that overturned or get them to change their opinion about whether or not it's a covered comp claim. But even if it's not, and that parking lot is controlled by a third party, then there could be a premises case there depending on the circumstances of how she fell and how the curb was maintained.
Yeah, I mean, Alabama has a going and coming rule, which, for workers' comp, if you're on the way to work or you've left work and get hurt, it's not covered by workers' compensation. You clock out, you're on the way home, and somebody runs a red light. That's not covered under workers' comp. But if you've parked in an employer-designated parking lot and are walking in, and that's where everybody parks, then there's some case law from the Alabama Supreme Court that says if you're hurt walking into work from an employee parking lot, that should be covered under workers' comp. And that's 100% of medical treatment that's completely covered, 2/3 of your pay while you're out of work on doctor's orders. And if you have some permanent injury, you're entitled to compensation on top of that. And the other thing is we're always looking for, is there more than a workers' comp case? Because workers' comp is not a great remedy. They haven't changed the rates since the Nixon administration. And, $1 got a lot in 1975. It doesn't get anything today. So one of the things I'm always looking at in a workers' comp setting is there a third party case? And basically that means, can I show that there was somebody else other than her employer, other than a coworker, that is responsible for this? Is the parking lot owned by some other entity and didn't stripe it right? It's not up to city code for, whether it's the striping lines or the actual height of the curb or whatever it may be. Is there somebody else? Because you can't sue your employer for anything other than workers' comp in this setting. That's what you get. Even if it was your boss who went out there and messed up the parking lot, you couldn't sue your boss for that. But if it's a third party, meaning some contractor, some maintenance group, may have a claim against them. May be tricky and difficult, but if somebody's really bad hurt, that's something we want to look at.
What about, she said that the HR said she's not the first person to trip there. Would that be any significance?
I would get that in writing first. I see if you can.
Like when she said it?
Well, like
later.
Maybe try to get it on an email chain or something like that. You saying that she said something, doesn't really hold a whole lot of weight in court. But if you can prove that there's prior incidences, yes, that's huge, particularly in a third party claim. If you can prove that that contractor or that parking lot maintenance group or the property manager, maybe they knew about that this was a problem and didn't do anything, yeah, that's really going to bolster your case. In the workers' comp case, it actually doesn't matter at all. In workers' comp, you don't have to prove fault. Yeah. People are like, my boss did X, Y, and Z. And I'm like, that's frustrating, but it actually doesn't matter. In Alabama, if you're hurt on the job, you don't have to prove they were at fault. It can be your own fault. You could trip on a curb. You could slip going up a ladder. That's still covered under workers' comp. But I see a lot of people angry at a supervisor or a coworker in a workers' comp injury. And that usually just is irrelevant under Alabama law.
Yeah, and it's not either or either, Aaron. So we're talking about two different types of claims, but there could be a workers' compensation claim here and a third-party liability claim, and you can pursue both.
Yeah.
So it's not like it's either one or the other.
But it may be more lucrative, especially if you're really hurting and you'd only have 2/3 of your pay where you could get more money if there's another person.
The biggest case I handled in my career on behalf of a severely injured man, we thought was just a workers' comp case. He had severe electric shock injuries to most of his body. It was amazing that he survived. But he was on the job, and we thought, God, we know he had a workers' comp case. He was an electrician by trade. But during the course of investigating it, we realized there was this independent contractor group who had been on site and had messed with the transformer and didn't tell anybody. And so that went from being a workers' comp case, and a big workers' comp case is $300,000. That's a big workers' comp case in Alabama.
That's not going to last you the rest of your life if you're out of work.
Yeah, because it's all based on these formulas that are outdated and the numbers haven't been updated in half a century. But if you get into a third-party case, there's no formulas. You can get things like pain and suffering, mental anguish, future loss of income, all those things that you cannot get in workers' comp. So I'm always looking when I have an on-the-job injury type case like hers, is there a third party responsible so we can go try to get more money for her?
And not all attorneys do a good job of looking for those third party claims. We handle workers' compensation claims, so that's something that we do, but a lot of personal injury firms kind of stay out of that and will send us what they believe is strictly a workers' comp claim. And then once we dig into it, we find out there's third-party liability. And it takes a trained eye, and you got to know where to look and the questions to ask. But that can just completely change a case.
And that's a personal preference. Yeah. Tommy, your dad, has said before he handles this because his folks were working folks, and he thinks it's important to continue to take those cases.
Absolutely.
Let's move on to Angie. She says, my son was invited to an adventure park for a classmate's birthday party. The coils and padding in one of the trampolines were missing. His leg fell through and he cut the inside of his thigh. His leg is badly bruised. I signed a liability waiver when he arrived. Does that mean they are not responsible for his medical bills. God, what kid isn't hurt at these these
Yeah.
places?
Yeah.
My kids were.
It's amazing that these places haven't been sued out of existence yet. I mean, what would you say, Barnes, to that?
The question about the waiver is an interesting one because it involves who I assume is a minor.
Mhm.
And, Alabama courts are skeptical about whether or not a parent can sign a waiver on behalf of their minor child and then whether or not that waiver is then enforceable, because in Alabama, a minor, they can't enter into contracts on their own. Generally, that kind of thing has to be court approved. In fact, every case that we handle on behalf of a minor in a personal injury case, it has to be court approved. Regardless of whether we had to file a lawsuit or not, we have to go to the court, and the court has to basically determine, yes, this is in the minor's best interest. I'm going to sign off on and approve this. So I would certainly take the position that waiver is unenforceable. And I think that there is a negligence claim there.
Yeah.
So there's potential for a case in what she just described.
I take my kids to those trampoline parks and I sign the waivers every time because I don't think they're enforceable. They just use them really
It's a deterrent.
as a deterrent. And they say, oh, you signed the waiver, you don't have a case. Like Barnes was saying, a child cannot waive their rights, even through their parent's signature at one of those electronic stands. They have rights, and it doesn't matter if their parent signs something. But you still have to prove that the trampoline park was negligent.
Right.
Like, they're not automatically liable just because your kid got hurt there, okay? You have to prove that they did something negligent, and that the explanation of that is just failed to use reasonable care. And the description she's providing, I think that's, close enough for a lawyer to look at it. They weren't covering a part of it. They should have. So, I mean, I think that's something to look at. It's a close call, though. I'd like to see like photographs.
Yeah, I would too.
And this takes me to this point, and I'll get off my high horse here. But if you're injured on somebody else's property, you are not thinking about this at the time. But it is so helpful to a lawyer to have photographs of what it was that you got hurt on, whether you slipped on something, tripped on something, something fell on you. And I know you're not thinking about that when you or your kid is hurt. But if you can go back later in time or have a friend or family member go run over there and just get one photo of it, that really, really, really helps me in being able to prove the case.
Very good. Always wonderful information. Thank you so much, Bart and Barnes, for this information about premises liability. And we look forward to hearing from you, our viewers, with your questions about any legal topic. You can email us at questions@siniardlaw.com or call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.